you hear me? Is the microphone on? We good? Okay. Good morning, everyone. Welcome to the Big Rapids Court Community Connections program today. My name is Dan Brubaker. I'm the Chief Operating Officer of the Michigan Supreme Court. I am here with Cheryl Nowak, who is the Chief Commissioner of the Michigan Supreme Court. And we are going to give you a brief overview of the Michigan Supreme Court and of this case in particular. Just a brief introduction to what we do. As the COO and Chief Commissioner, we're kind of responsible for overseeing the flow of cases in the Supreme Court as they come in all the way from the time that they get filed until the time that they are disposed of. There's a lot of different directions a case can go when it gets filed in the court, so it's a lot to keep track of. But before we start, I want to do this. Can I get a big round of applause for all the educators in the audience? There were a lot of educators and student mentors who worked with the students beforehand, and those of us who put this together really appreciate it when that can happen. So, let me tell you about my bosses, the justices of the Michigan Supreme Court. There are 7 justices on the court, and they decide all the cases by a majority vote. First up is Chief Justice Kavanaugh. The Chief Justice is elected by her fellow justices. She's not appointed like in the federal system. I had the honor of working with Justice Kavanaugh's father, Michael Kavanaugh, when he was a justice. Justice Megan Kavanaugh grew up in East Lansing, and she joined the court in 2019 after spending many years in private practice as one of Michigan's top appellate attorneys. She is also the Supreme Court's liaison to the tribal courts. Next up is Justice Zara, who is the longest-serving justice on the court right now. Before he joined the court in 2011, Justice Zara was a circuit court judge, and then he was a Court of Appeals judge, and then he became a Supreme Court judge. And he also teaches at the University of Detroit Mercy Law School. And next up is Justice Bernstein. Justice Bernstein joined the court in 2015. Prior to being elected to the court, Justice Bernstein was with the Public Services Division of the Sam Bernstein Law Firm, where he did a lot of work advocating for disability rights. Although he is, as far as I know, the only blind justice in the entire nation, he is an avid runner and a marathoner, and we even ran a race together in Muskegon a few years ago. And next is Justice Welch. Justice Welch took the bench in 2021. She is our only justice from Grand Rapids, and before she became a justice, she practiced labor and employment law, mostly at large firms, but she also opened up her own smaller firm. She's also served on the East Grand Rapids Public Schools Board of Education prior to being a justice. And then we have Justice Bolden. She joined the court fairly recently in 2023. Before becoming a justice, she was a state representative in the Michigan House of Representatives. There she worked extensively on criminal justice reform and legislation to protect survivors of sexual violence. And then we have Justice Thomas. Justice Thomas joined the court earlier this year in 2025. Before becoming a justice, she was on the faculty of the University of Michigan Law School for over 20 years and was the co-founder and director of the law school's Juvenile Justice Clinic. And finally, and this is his first roadshow, we have Justice Noah Hood. Justice Hood is a graduate of Yale College and Harvard Law School. He was an assistant U.S. attorney and then a circuit court judge in Wayne County and then a Court of Appeals judge, and earlier this year became a Supreme Court justice. So you can kind of see from this pyramid, well, first I should note the justices are elected to 8-year terms unless they are appointed, and there's appeals kind of go up the pyramid. So there's a lot of circuit court and district courts in Michigan. The counties have circuit and district courts, and if you appeal from those courts, you go up to the Court of Appeals. And the Court of Appeals sits in several places in Michigan, and there's a lot of Court of Appeals judges. But if you go from the Court of Appeals up, you go to the Michigan Supreme Court. And there's just one Michigan Supreme Court, and it's in Lansing, and it usually hears cases there at the Hall of Justice in Lansing. Oops. Here we go. Unlike most of the lower courts, the thing that's unique about the Supreme Court is that it doesn't really have to take cases. People have to file what's called an application for leave to appeal. parties essentially have to ask the court to take their case, and we get about 1,400 to 1,600 applications every year. We only hear arguments in about 80 of those cases. The court, of course, is generally most interested in the important cases that they think are going to have an impact on the whole state of Michigan and are important to the jurisprudence of the state of Michigan, which is the law of the state of Michigan. It's important to recognize as well that unlike the lower courts, or unlike the trial level courts, the Supreme Court doesn't have like juries and witnesses, and it doesn't hear evidence. Instead, each party is here essentially attempting to persuade the justices that the lower courts got it wrong somehow. You know, the Court of Appeals erred and you need to fix it. Or the other side is saying, no, the Court of Appeals got it right. You don't need to do anything with this case. There are no objections. There's no witnesses. The attorneys don't like jump up and interrupt each other during argument, although the justices are free to ask questions, and they usually always do. So that is it for the primer on the court. And now Cheryl Nowak will give you a quick rundown of the case you are about to hear.
Good morning, and thank you, Dan. As he said, my name is Cheryl Nowak. I'm the Chief Commissioner at the Michigan Supreme Court. Today, we all have the honor of seeing the work of the Supreme Court in action. I am here to share some background information about the case that the court will be hearing today, People v. Wilkins. And I'm going to talk kind of fast because I have a lot of material to go through. There we go. So to start with the facts. So in this case, in January of 2023, a police officer stopped a defendant because he was speeding. As the officer approached the vehicle, he immediately noticed the odor of marijuana. The officer obtained defendants and the passenger's driver's licenses and noticed that they were both under 21 years old, which meant that if they were in possession of marijuana, they would be guilty of a civil infraction. The officer called for backup, which arrived 5 to 10 minutes later. Defendant was asked to exit the vehicle, which he did. The officer searched him, but didn't find anything. Although defendant and the passenger initially denied possessing any marijuana, the passenger later admitted that there was a small amount of marijuana in the vehicle. After this admission, the officer searched the passenger compartment of the vehicle, including a backpack, and in the backpack, he found a handgun. Defendant admitted that the gun was his and that he did not have a concealed pistol license. Defendant was charged with carrying a concealed weapon in a motor vehicle. Defendant moved to suppress the evidence of the gun as the fruit of an unlawful search and seizure in violation of the Fourth Amendment. There are several legal principles at play here. Most importantly, we have the Fourth Amendment of the United States Constitution, which guarantees the right of persons to be secure from unreasonable searches and seizures. A search is constitutionally reasonable where the police possess a warrant or the search falls within one of the well-established exceptions to the warrant requirement. And then finally, the exclusionary rule, when it applies, forbids the use of improperly obtained evidence or the fruit of the poisonous tree at trial. And as I said, there are several exceptions to the warrant requirement. 2 of them are at play in this case. The first one is known as a Terry stop. A Terry stop allows an officer to conduct a brief warrantless seizure of a person when the officer has a reasonable and particularized suspicion that this person is engaged in criminal activity. A pat-down search for weapons, however, can only be conducted if an officer has reasonable suspicion that the person is armed and dangerous. The second exception at play here is known as the automobile exception. When the police have probable cause to believe that an automobile contains contraband or evidence of a crime, a search of the automobile is allowed. In 2000, when marijuana was illegal for all purposes under Michigan law, this court in People v. Kaczmarek held that the odor of marijuana standing alone constituted sufficient probable cause to support a search under the automobile exception. In 2018, the Michigan Regulation and Taxation of Marijuana Act generally decriminalized the use and possession of certain amounts of marijuana by adults aged 21 years or older. In April of 2025, this court in People versus Armstrong, a case that was actually heard last fall in Marquette, held that the odor of marijuana standing alone no longer constitutes sufficient probable cause to support a search under the automobile exception. Something more is now required. As I said a moment ago, in the case that is being argued today, defendant was charged with carrying a concealed weapon in a motor vehicle, and he moved to suppress the evidence of the gun as the fruit of an unlawful search and seizure in violation of the Fourth Amendment. The circuit court denied defendant's motion, concluding that the Terry stop was justified because defendant was speeding, and then the officer detected the odor of marijuana and discovered that defendant and his passenger were both under the age of 21. For the same reasons, the circuit court concluded that the officer had probable cause under the automobile exception to search the vehicle and its contents. Defendant then appealed to the Court of Appeals, which affirmed in an unpublished decision. The Court of Appeals held that the search was justified under the automobile exception. It said that the probable cause exists to support a warrantless vehicle search so long as facts adequately support that the suspected activity is generally unlawful, even if only a civil infraction. It also said that the odor of marijuana, knowledge that defendant and the passenger were under the age of 21, and the passenger's admission that there was marijuana in the vehicle gave rise to probable cause to believe that contraband, that is illegally possessed marijuana, would be found in the vehicle. With regard to the Terry stop, the Court of Appeals held that although the initial stop was justified because defendant was speeding, the search of defendant was not justified because the officer did not have reason to believe that he was armed and dangerous. Nevertheless, it concluded that the search of defendant did not reveal any evidence and it did not in any way open the door for the later search of the vehicle. That is, it concluded that the vehicle search was sufficiently distinct and severable from the improper search of defendant, and thus the gun was not the fruit of the poisonous tree and need not be suppressed. The defendant then sought leave to appeal to the Supreme Court. Defendant argues now that the gun should be suppressed because the officer exceeded the scope of a permissible Terry stop when he searched him, and because the gun was discovered after that illegal search, it must be suppressed as the fruit of the poisonous tree. Defendant also argues that the automobile exception does not apply to him because the officer only had probable cause to believe that a civil infraction occurred, not a crime. The Supreme Court ordered oral argument on the application. The parties submitted supplemental briefs. The prosecution and the defendant will give oral argument here today. And the issues before the court today are, there's three of them. First, whether the search of defendant's person by the police officer exceeded the permissible scope of Terry versus Ohio. The second is, if so, whether the discovery of the recovered weapon was causally connected to the search of defendant's person. And then third, whether the search of defendant's vehicle was permissible under the automobile exception to the warrant requirement, where the officer had probable cause to believe that defendant was responsible for a civil infraction for possessing marijuana while under 21 years of age, contrary to the protections of the Michigan Regulation and Taxation of Marijuana Act. So the court is going to hear those issues today. Students, as you watch this case, consider what the implications could be for the decision regarding whether the automobile exception to the warrant requirement applies to searches for evidence of civil infractions. How could this decision affect other cases? I hope you have lots of questions and think of more questions as you watch oral argument. There will be time for you to ask those questions after the oral argument, so hold your questions until then. And with that, let's proceed with oral argument.
God save the United States, the state of Michigan, and this honorable court.
Good morning. I'm Cole Heiss, Student Council Mayor. Welcome to Big Rapids High School for the 32nd Michigan Supreme Court Community Connections Program. We would like to thank the Michigan Supreme Court justices as well as our local judges for supporting the Community Connections Program goals to provide students with a greater understanding of the courts and Michigan's judicial system. We ask that you turn off all electronic devices at this time. Please welcome to the stage 49th Circuit Court Chief Justice Kimberly Boer.
Good morning. On behalf of the judges of Osceola and Mecosta County, I would like to thank the justices of the Michigan Supreme Court for making this opportunity available to our community. A community that is not only a beautiful place to live, but is also rich in history. As most of you know, Big Rapids is the home to Ferris State University, which was founded by Woodbridge Ferris. Mr. Ferris also served as the 28th governor of the state of Michigan. On the campus is the Jim Crow Museum, which houses the nation's largest collection of artifacts from the segregation era. This area is also, at one time, was the home to Anna Howard Shaw. She was a leader of the women's suffrage movement. She was also a physician and one of the first women to be ordained as a Methodist minister in the United States. Most of you have also heard the hymn, The Old Rugged Cross. The composer of this hymn, George Bernard, retired to the Reed City area, which is about 15 minutes from here, and I know that we have students from Reed City here. And he lived there until he died in the year of 1958. Not far from Reed City, Michigan, is the small town of Everett. That's where I come from. In Everett is the grave of Joseph William Guyton, who laid down his life for our country. Mr. Guyton was the first American soldier killed on foreign soil during the First World War. As an advocate for lifetime learning, I would also like to thank all of the administrators and the teachers for realizing what a wonderful learning experience this is for our students and encouraging their participation. Not only are there our high school students here, but there are college students here that are not only watching our oral arguments in front of the Supreme Court, but making memories today that will hopefully be able to be shared with their children and grandchildren someday. It is a rare opportunity for us to be able to see the oral arguments take place here in person in front of the Supreme Court. I am now a judge, however, I have been in the legal field for over 30 years. In my lifetime, I have argued only 2 cases in front of the Michigan Court of Appeals. I have never argued to the Supreme Court. I have only seen oral arguments to the Michigan Supreme Court through a computer screen. I myself am excited to participate in this event. This event has allowed myself and Judge Clapp to open a dialogue with some of the students in attendance today. This conversation has not only been regarding this case, but the study of law in general. We are hopeful that this event will spark your interest in the pursuit of a career in law. We would invite all of you to contact your local courts or to come visit the court, to watch open court. If you are interested in a job shadow opportunity as well, we are more than willing to do that. Again, I would like to thank everyone who has spent countless hours to make this a success. With much ado, I would like to introduce the award-winning Big Rapids High School Band to perform for us before the arguments begin.
All right. Good morning, everyone. Welcome. That was a fantastic performance by the band. Let's give them another round of applause. They did. Wonderful. So, welcome to the 32nd Court Community Connections program. On behalf of myself and my colleagues here on the Michigan Supreme Court, we are delighted to be here at Big Rapids High School to continue this important tradition of bringing the court directly into the communities across our great state. So before we turn to today's case, I want to say a couple thank yous. Thank you to our hosts, students, and educators for joining us. We are especially pleased to welcome students from Big Rapids Middle School, Big Rapids Virtual School, Chippewa Hills High School, Coopersville High School, Everett High School, Ferris State University, Grand Rapids Catholic Central High School, Mecosta Osceola Career Center, Morley Stanwood High School, Reed City High School, and then all of those watching on our live stream. So before we proceed, I would like to present a formal resolution of appreciation to Big Rapids High School, to the principal, Ronald Pinkham, for serving as our host and for the outstanding support of the faculty, staff, and administration in making today possible. So if the principal could come up, if he's here. Oh, here it comes. Thanks. Thank you. On behalf of the court, thank you for hosting us and for all the help that you've given. Thank you very much. Thank you. All right, so today is special for several reasons. Court Community Connections is dedicated to building public trust and improving understanding of the judicial system by engaging directly with Michigan youth and communities. It is one of the most meaningful ways that we feel that we can open our work to the public. However, we can't do this alone, and so I wanted to extend a special thank you to the many, many people that made today possible. First being the Mecosta Osceola Intermediate School District and the leadership here at Big Rapids Public Schools for welcoming us and hosting today's event in your auditorium. To Chief Judge Kimberly Boer and Judge Amy Clapp and the 49th Circuit Court for their leadership and partnership. Judges and staff from the 77th District Court and other local courts, along with other local dignitaries and members of the bar. The faculty and leadership of Ferris State University, especially Professor Emily Franstead, whose collaboration with local courts and bar members helped prepare students for today's case. The officers who keep us safe, including Michigan Supreme Court Security, the Michigan State Police, and local law enforcement. A special thank you to our Chief Operating Officer, Daniel Brubaker, and Chief Commissioner Cheryl Nowak, who led today's case briefing, and then will guide the post-argument debrief with the students. A special thank you to counsel in today's case, Kimberly Manns and Zachary Houghton, for participating in oral argument. This is not the typical oral argument. I give you a lot of credit for being here. Not the typical environment, but everything will be just fine, I promise. And all of our program partners and volunteers who made today possible. And then finally, I have a couple welcomes. I would like to welcome our newest Supreme Court Justice. He's down here today. Sorry, I'm all turned around. Justice Noah Hood. This is his first Community Connections. And our new court crier, Ryan Tomlinson. This is also his first Court Community Connections. So before we proceed, I just wanted to highlight two key messages. And the first is that we're here today because community engagement builds public trust. And the judiciary's most important currency is trust of the public. Programs like Court Community Connections strengthen accessibility, fairness, and confidence in our judicial system. Second, even as we innovate to make courts more accessible, our commitment to judicial independence, the rule of law, and service to the people of Michigan remains constant. So, a few housekeeping notes. Some have already been mentioned, but once oral arguments begin, we ask that you refrain from taking photographs except for credentialed media and court photographers. There will be an opportunity later for photographs after we have returned from deliberations. As mentioned before, silence and power down cell phones. And after the arguments conclude, we will leave the stage. Please remain seated because the student debrief with our staff and attorneys will take place after we leave the stage. So a little bit about what you're about to see. Oral arguments, they are a vital part of appellate decision making. The questions asked and arguments presented today help us craft decisions that clarify Michigan law. Students, you've been briefed on the facts and legal issues in the case of People of the State of Michigan versus Freddie Wilkins III. That is our court case number 167737. Listen closely, think critically, and consider the questions you would ask. Once the court issues its decision, we encourage you to read the opinion and reflect on whether you agree with our reasoning or whether you might have ruled differently. My hope is that today's experience deepens your understanding of the rule of law and inspires you to consider careers in public service or law. And for those interested in taking that step, I know Judge Boer had encouraged job shadowing. I wanted to let everyone here know of another opportunity that is designed specifically for students. It's Exploring Careers in the Law for High School Students. It's a unique summer experience for rising 10th graders through new graduates who are curious about legal careers. Participants in the program will argue a case as if before the Supreme Court and work closely with law students, attorneys, court staff, and members of the judiciary to prepare. The program will be held in July of next year, July 2026, at the Hall of Justice in Lansing, with a one-day regional experience. There will be another program regionally that will be announced shortly. So you can find more information about this program in the program that you received today, and it's also at the court's website. So with that, we are honored to share the day with you, and I will call the case. And so our case is People of the State of Michigan versus Freddie Wilkins III, docket number 167737. This is a mini oral argument on the application. Each side has 15 minutes for argument. There is a 2-minute fire-free zone, which you may waive if you choose. And then, Mr. Houghton, if you would like to reserve any time for rebuttal, you may do so. We just ask that you try and keep track of that. But you may proceed when you're ready.
Good morning. Zachary Houghton on behalf of the appellant, Freddie Wilkins III. I'm joined at council table by my colleague, Laura Joyce. I intend to reserve 3 minutes for rebuttal. May it please the court. This case presents 4 legal issues of major significance to this state's jurisprudence. First, this case presents the issue of whether the smell of marijuana alone establishes reasonable suspicion that an individual under 21 unlawfully possesses it. It does not. Now that marijuana is generally legal and its possession, use, and odor are ubiquitous, the smell of marijuana is not particularly probative of who is possessing marijuana or of whether it is being possessed unlawfully. Second, this case presents the issue of whether reasonable suspicion of a civil infraction is sufficient to initiate a Terry stop. Again, it is not. Terry authorized brief stops on less than probable cause to investigate, quote, criminal activity, and did so explicitly because of the government's weighty interest in, quote, crime prevention and detection. Neither the holding nor reasoning of Terry applies to civil infractions. Third, this case presents the issue of whether evidence discovered after a Terry stop has been extended by an unrelated inquiry should be suppressed. It should be. A Terry stop remains lawful only so long as unrelated inquiries do not measurably extend its duration. Therefore, evidence discovered after a Terry stop has been extended by an unrelated inquiry is a direct fruit of a seizure that has become unlawful. Fourth, this case presents the issue of whether the automobile exception authorizes a warrantless search for evidence of a civil infraction. It does not. The U.S. Supreme Court recognized the automobile exception over a century ago, yet in the 100 years since, it has not expanded it to searches for civil infractions.
Counsel, what should the officers have done here in your view? What would have been proper conduct here?
In this
Just
case,
a speeding ticket? Is that?
correct. In this case, the officer had probable cause to believe that Mr. Wilkins had committed a moving violation. So the initial stop was fine. After the initial stop, the only additional facts that were gleaned were, one, that there was the odor, generic odor of marijuana, and two, that the passenger and the driver were both under 21.
What do we do with the Recreational Marijuana Act and its very clear language about prohibiting marijuana for those who are under 21? Does that matter at all? I know California had a case where they specifically talked about that statute specifically said marijuana is not considered contraband. So they very directly addressed it. Ours is not quite that clear. So I'm wondering if you could address sort of the purpose behind the law and the fact that it is supposed to be banned for 21-year-olds. Does that impact the case?
I'd push back slightly. The MRTMA does prohibit the possession of marijuana by an individual under 21. However, that does not necessarily mean that possession by someone under 21 is unlawful, because there's also the Medical Marijuana Act, right? As to your question, whether marijuana is contraband, I guess that depends on whether contraband is defined to be anything unlawful to possess, right? Or whether contraband is the possession of a property that's criminal to possess, right? And that's one of the main rubs when it comes to the automobile exception argument that we raised here. As far as is it contraband, whether a statute defines something as contraband, I think is a separate question to whether it's considered contraband for Fourth Amendment purposes.
Counsel, does it also boil down to the amount, where you could have a criminal amount of contraband and a non-criminal amount of contraband? You could have, for example, in this situation, contraband that would amount to a civil infraction, or potentially contraband that amounts to a crime.
It's our position that contraband for Fourth Amendment purposes is property, the possession of which is criminal. So for Fourth Amendment purposes, I would push back and say that if the possession is a mere civil infraction, it's not contraband for Fourth Amendment purposes.
So then how do we arrive at something that's workable for the officer that's making that stop, right? What more, I mean, going back to what Justice Welch asked, what more would the officer have to have said at the suppression hearing to get to the point of, well, this was, I did have not probable cause, but I had there was a reasonable probability that there was contraband in this vehicle?
Are we talking in relationship to the automobile exception or the Terry stop?
To the automobile exception. Once we get past the Terry stop, once we get to the point where he's now relying on the automobile exception, what more would they need to say? Would it have to be the trunk appears to be weighted down and we know that there's something else in there? What additional steps or additional testimony would you be looking for?
Sure. Our standard would be that they would have to have probable cause the vehicle contained evidence of a crime. Now, what would give the officer probable cause, I think, is what your question is, in addition to smell alone. And there's numerous factors that could help get the officer to probable cause that simply weren't present here. So the smell and being under 21 is not enough to believe that there's 2.5 ounces or more of marijuana in the vehicle, or that they used in the vehicle, or that they were operating while intoxicated. Additional signs would be signs of present or recent use, lit joint, smoke, the presence of masking agents. There could be physical signs of impairment, bloodshot eyes, slurred speech, impaired coordination, excessive laughter. There could be erratic driving.
Does his denial matter? Like, I mean, there's obviously multiple factors here. I know the Court of Appeals relied upon to get to the sort of alternative pathway here, probable cause. They relied on, pulled over for speeding, denial, alleged smell, denial, and then obviously got to the passenger statement too. And they said all of that together. So obviously I understand you're saying passenger statement shouldn't come in under your argument.
Sure.
So we would have a denial with odor plus age. So, I mean, I understand you're saying that's not enough for, is your argument that it's not enough for probable cause of a crime? Or do you, let me rephrase this. Do you believe that they can have probable cause for a civil infraction? Or are you saying, no, we can't even get to civil infractions?
I believe that they probably had probable cause for a civil infraction once the passenger admitted that there was marijuana in the vehicle, shake in the vehicle specifically, which indicates a small amount of marijuana. It's the particles that fall off.
But we have to, so I understand your argument is we can't consider the passenger statement, so now we're left with what happened before then, and that's not.
And I'm saying even with the passenger statement, there's not probable cause of a criminal amount, because then you're left with the smell of marijuana, which now that marijuana is legal, the smell is ubiquitous, it's everywhere. So it's not particularly probative of who's using, how recently they used, where they used, and it's in fact not even particularly probative of whether its use was unlawful or its possession was unlawful, because there are additional regulations in place, including the Medical Marijuana Act and the fact that industrial hemp-derived products are also legal for individuals under 21. So it's not particularly probative. So I would say that absent the admission, there's not even probable cause of a non-criminal amount in the vehicle.
So help me with the distinction between possession and use. So as we said in Armstrong recently, the smell alone is not sufficient because of the quality that it can't determine, that somebody actually used it or when and there are typically other indicia that might be relevant to that probable cause determination, some of which you mentioned, right, of impairment or evidence in the car that's plainly viewable of recent consumption or that. But for a person under 21, the mere possession of it is prohibited. So what would be indicia if you're under 21, you smell it? What is indicia sufficient? What other indicia would give us an indication or give an officer an indication of the possession? We're not talking about use. It's just merely the possession and a distinction between 2.5 or more than 2.5, which would be a crime, right, for anyone to possess it over that amount.
Well, I think that it would be difficult absent an admission to get to 2.5 ounces. Now, less than 2.5 ounces, I think there would be a number of factors that could aid an officer in getting to probable cause of a civil infraction amount. And it would be the typical sort of indicia that officers always rely on: nervousness for movements, flight, evasiveness, history of drug use, visible drug paraphernalia, rolling papers, pipes, bongs, etc.
Why isn't denial that you have it also one of those indicias? If why saying no, I don't have any, why is that not part of the calculation?
So the trial court didn't make this finding, first of all. Assuming that the trial court did make the finding that there's a denial at the start, right? That there wasn't an admission until after the search of Mr. Wilkins, which we assert was unlawful, right? And so the officer had no way to know that denial was possibly untrue until it was too late. Now, even if it was possibly untrue, it doesn't give probable cause to think there's more than 2.5 ounces in the vehicle. All a reasonable officer would conclude from that would be they didn't want to get in trouble and they didn't want a ticket for having a joint in the car. And so I don't think that even if there was denial, the trial court didn't find it, even if the denial was a lie, I don't believe it was, if it did occur, because there's a distinction between, I think, marijuana and shake in common parlance. But even if we're simply left with a lie about a unlawful amount of marijuana, and the justification for that is obvious, they didn't want to get in trouble. It doesn't, to me, give probable cause, it doesn't give the officer probable cause to believe that there's more than 2.5 ounces of marijuana in the vehicle. And if I could just point out that that is a large amount of marijuana. I cited in my brief that a typical joint is 0.32, which would mean that there would be 200 or so joints in the vehicle. So it's a large amount of marijuana.
You came up and said, this, since the passage of the act, the smell of marijuana is everywhere. I'll challenge you on that. The smell of marijuana is common, but it is not everywhere. And doesn't it matter that this officer walks up to the car, window opens, now they smell it? Doesn't that give the officer some reason to think there's something going on here that might not be appropriate?
I think there's some reason. It would give some reason to think that they perhaps were in the presence of someone that used marijuana. I think it could also
that combined with them being under 21. Does that not take it to the next step?
The next step of
having more reason to consider searching the vehicle under the vehicle exception.
No, I don't believe that additional fact gives rise to probable cause to believe the vehicle contains 2.5 ounces.
Because it's a civil infraction?
Correct.
Okay.
And to be clear, I don't believe that the smell gives rise to probable cause of a civil infraction. I don't believe it even gives a rise to reasonable suspicion of a civil infraction, but I'm quite convinced that it doesn't give rise to probable cause of a crime.
Okay. But even on the civil infraction, the window rolls down, you smell it, you know you're not supposed to be operating a vehicle while consuming marijuana, and then the officer knows they're under 21. You don't think that's enough to even to say, I think there's a civil infraction going on here?
No, I do not.
Okay. You made mention of the fact that there was a search of the person and that was an illegal search. I'll agree with you on that. That really doesn't have anything to do with your position, does it? You're really, because the search of how does the search of the person contribute to the search of the vehicle?
Because the search of the person extended the Terry stop, assuming the Terry stop was lawful at its inception. And because there was an extension of the Terry stop, the Terry stop at that point became unlawful, and the search of the vehicle is a fruit, not necessarily of the search of the person of Mr. Wilkham himself, but a fruit of the unlawful seizure. The seizure was unlawful because of the search of Mr. Wilkham's person.
So, Counselor, I take your argument to be under Rodriguez, that it extended that. Is there anything in our record about the time, like how long the search, or how long the stop was extended or the detention was extended by that search? Is there anything in our record about time, length of time?
No, it would just be the time it typically takes to search an individual. A minute or so would be my guess.
It wasn't even a full search, it was a pat-down, right? A frisk.
I'm sorry?
A Terry frisk.
No, it was an evidentiary search.
Okay.
That's what Trooper Tompkins testified.
I was trying to figure out what time frame you were talking about. The full
yes,
search
the search of Mr. Wilkins' person.
Okay, you have 20 seconds.
I'll reserve.
Okay. Thank you.
Good morning. My name is Kimberly Mans. I'm an assistant prosecuting attorney for Kent County, here today representing the plaintiff appellee, people of the state of Michigan. The touchstone of the protections of the Fourth Amendment is reasonableness. We're protected not against all searches and seizures, but against unreasonable searches and seizures. And the trooper's action in searching this vehicle was reasonable because he had probable cause to believe that that vehicle contained contraband, unlawfully possessed substance or goods. And now with MRTMA, with the legalization of recreational use of marijuana by adults, this court has held that the odor alone of marijuana no longer supports probable cause to search a vehicle without a warrant under the automobile exception. However, the facts of this case include more than just the odor of marijuana, and that important fact initially is that no one in the vehicle could legally possess any marijuana because they're both under 21. So does the vehicle exception to the warrant requirement allow an officer to search under these circumstances? And the people maintain that it does, and I will take any questions that you have.
Counsel, do you acknowledge that if we agree with you, this would require on some level an expansion of the existing automobile exception, that we would have to expand it to contemplate contraband that represents potentially a non-criminal amount of contraband?
I don't know if I would call it an expansion. I would call it looking at the plain language of the Fourth Amendment, because the plain language not only says evidence of a crime, it specifically separately says contraband. So if you look at, I would agree that under what we normally think of as probable cause to search, because a lower amount would be a civil infraction, that would be an extension, but it's a probable cause to believe contraband is in the vehicle.
Let me put it differently. There's no Michigan cases or U.S. Supreme Court cases that have said this sort of search, an automobile search, is okay for specifically a civil infraction level of contraband.
Not that I know of.
Okay.
But even if it's a probable cause to believe a civil infraction has occurred because of the amount of marijuana, the MRTMA statute itself, under any of the penalties, includes forfeiture of that marijuana. I would suggest that where there's probable cause to believe that there is contraband in a vehicle, and I'm trying to think of an instance where this wouldn't be, or where this would be something other than a situation like we have here.
Can I give you a
where no one
hypothetical
in the-
about that? Because this is the one that's concerned me.
Where it goes beyond.
Yeah, where you have a 15-year-old or a 16-year-old that's smoking a cigarette, and they're not allowed to smoke cigarettes at 16 years old. Is there now a suggestion that there's untaxed cigarettes in the trunk of the car, which would be contraband? In fact, you've got a U.S. Supreme Court case dealing with precisely that situation.
Okay.
Would that allow an officer to say, search, if they see a 16-year-old smoking a cigarette?
If it's an illegally possessed good or substance, and they have probable cause to believe that there's evidence of that in the vehicle, then yes, it would. I would limit it to contraband. I know that opposing counsel in briefing talked about worries about a black box being taken or evidence of other civil infractions. I think that can be limited by limiting it to contraband. And when we're looking at this case, any marijuana in that vehicle is contraband because of their ages.
Thank you.
If we consider,
Counsel, so in your view, I mean, in this case, I know, as I asked Brother Counsel, the Court of Appeals sort of relied on all of the statements and said the totality reached the probable cause standard. If we were to, agree with the defendant that the Terry stop sort of impermissibly extended to the passenger and the passenger's comment cannot be considered, so we're basically left with pulled someone over for speeding, alleged denial of, smell of marijuana, denial of use of marijuana. Is that an underage? Is that enough? Is that enough right there?
the Court of Appeals, as you said,
They lumped
used
the
four.
statements in.
They used
so-
all of it together.
Right.
But
I
the
mean, just
odor of,
age and smell, is that enough?
I think so. The odor itself, and knowing that no one in that vehicle can legally possess any marijuana, that makes that marijuana in the vehicle contraband.
So it's interesting, Justice Hood's question, I mean, I think you would agree, it sits differently when we're talking about cigarettes.
Right.
I think we know that. And I'm sort of wondering, is there like this continuum on civil infractions, like some that are more about protecting the public than others? I mean, I agree that that hypothetical presents a tough situation.
Right. Because with a cigarette, the concern is more for the health of the individual, whereas with something like marijuana that can affect how someone's driving, how someone's acting, that reaches more into the safety for public as well.
I'm struggling with the nature of marijuana smell, right? Like, why is the smell of it, the knowledge of being under 21, and maybe even the denial, why is that not equally as probative of the possibility that, the parent who owns the vehicle smokes in their car and the kid, the under 21 is driving it, not possessing? I mean, why is it, given the nature of it, right, that we know, as we said in Armstrong, the smell of it doesn't doesn't really indicate consumption or time of consumption or identity of who consumed it, right? And why is it, and if it could have been just whoever uses the vehicle, parent or anyone else, consumes it, and this is just somebody, I mean, why is that not, what pushes it over to think, well, I think we can search the car because it's indicating, it's more indicative of possession by a minor as opposed to just presence of the smell in the vehicle?
Well, I think part of that comes with the trooper's experience, because smelling marijuana, smelling burnt versus fresh, and certainly the strength of whatever odor there is, that can be part of that determination. But when I looked at Armstrong, I mean, this court really, after MRTMA and after the fact that some marijuana, certainly by adults, it's legal to have possession of. Before that, when marijuana was illegal across the board, the odor alone was enough. So I guess I didn't read Armstrong to say anything other than, now that it's legal for certain individuals in certain amounts, we can't assume that. But in this case,
there's no quantity that would have
there's
been
no
legal.
quantity that would be legal. And certainly, after a search, we don't have that instance in this case, but after a search, if that small amount is found and it's a civil infraction, the under 21-year-old will simply still be facing a civil infraction. This case, of course, comes up because it was a firearm that was found during the search.
Can I ask, just back to your point about the relying on the experience and knowledge of an officer between fresh and burn? Do we have information in our record about that characteristic of the smell?
I do not believe so, not in the record we have now. Right now, we just have the preliminary examination testimony.
Okay.
And that testimony didn't really distinguish what exactly the smell was.
Versus, no, it did not. If we go through how Trooper Tompkins treated this stop, and the way, I think there was a question on what they should have done, if not. Trooper Tompkins had probable cause to believe that the civil infraction of speeding took place, so that allowed him to do the traffic stop. As he walks up to the car, he gets the odor of marijuana and then checks IDs. They're all underage. Again, in our opinion, he has probable cause at that point. There's denial as well, but at that point, he calls for backup because he's alone. There's two individuals in the car. That's reasonable under officer safety. Once backup arrives, he then approaches the car again, and at that point, he asks the driver out, later asks the passenger out. That's also permissible at any traffic stop. I conceded in our brief that a evidence search of the driver exceeded Terry, but that was part and parcel of them preparing to do the vehicle search. There's nothing found on the driver, and so the probable cause to search is still there and separate from any search of the individual.
What is even if the evidentiary search was unconstitutional, is it relevant at all that the evidentiary search didn't produce anything that would corroborate, in fact, possession? I mean, it'd be one thing to say, okay, I get your position, they're under 21, it's the smell, it's the denial, that gives me probable cause to search it. Does the fact that there's nothing on the individual back that up some and say, maybe there isn't probable cause, because one of the most logical places that the possession would be found is on somebody's person.
I would think that you could also argue the opposite. If there's nothing found on his person and you have an odor coming from the vehicle, that's an even greater indication that you'll find contraband in the vehicle itself. But
But
beyond,
Counselor, isn't it at that point really an investigatory evidentiary search and not a traffic stop anymore? So that's Brother Counselor's point, that it's now extended beyond a traffic stop to an investigation of this marijuana. And I think that's the Rodriguez
correct,
argument.
because there's probable cause to believe there's marijuana that's not lawfully possessed that's in the vehicle. I would agree with that.
And so you think that's appropriate, that shouldn't have been, once the search is done and there's nothing recovered, the officer gives this gentleman a ticket for the speeding and potentially even a civil infraction for marijuana and drives off. You think
If
that at
that
that
had
point,
been what happened, yes, yes. Unfortunately for Mr. Wilkins, there was a firearm in the vehicle.
So how do you help us divide the, talking to the driver and then talking to the passenger, and why those are separate?
It can also be part and parcel of that investigation. He has probable cause to search the vehicle, but as he removes them, which is going to be necessary for the search of the vehicle, remove the occupants themselves, as talking with them, that is part of the investigation as to who had this in the vehicle. Once he finds any, that's where the passenger's indication that there was shake left in the vehicle, and it would go towards perhaps who would be responsible for what is found in the vehicle itself. If, in our case, the passenger is the only one that indicated that she had some marijuana in the vehicle, if marijuana itself had been found in that vehicle, then we know which of the under 21s would be responsible for the civil infraction. Think of any other questions. Do you have any other questions for me?
Counselor, if the driver was 21 and the passenger was 20,
Okay.
would there still be a reasonable suspicion of criminal activity or probable cause to search the vehicle under the automobile exception?
It would depend on the circumstances. I don't think there would be. You would go back to the indicators that you would normally look at. Are there indicators that there was recent use? Are there indicators that, is there a duffel bag sitting open in the back with what might be more than would be allowed? But the smell alone in that situation, because there's an individual in the car who can legally possess an amount of marijuana, I don't believe that would reach that same level. Thank you.
Thank you.
I have one point to make.
All right.
Sister counsel said that the age, smell of marijuana and age alone would be sufficient to establish probable cause. If that's true, it means every person under 21 with a parent, sibling, roommate, classmate, coworker, neighbor, friend who possessed or smoked marijuana in their presence, every person under 21 who legally possessed or use certain hemp-derived products, and every person under 21 using marijuana consistent with the MMMA could be subject to repeated investigatory stops and vehicle searches at the whim of a police officer. That can't be right, and it isn't. The Supreme Court has stated that a set of facts does not establish reasonable suspicion if it describes a very large category of presumably innocent individuals. Thank you.
Thank you. The case will be submitted. Thank you for your arguments.
You can go ahead and sit down. We will begin the debriefing in just a minute. We just need to set up at the table behind me.
Well, it has ashwagandha, lion mane, reishi mushroom. Yeah, supposed to be, yes.
Okay, I think we're ready to go ahead and get started. I want to start by saying, like, arguing in front of any court can be a little bit stressful, and arguing in front of the Michigan Supreme Court under even normal circumstances can be a little nerve-wracking, but arguing in front of the Michigan Supreme Court with your back to hundreds of high school students and some judges is above and beyond the call of duty. So please give a round of applause to our attorneys here today. I want to thank Big Rapids High School for hosting us here today, and I want to thank all the people who helped put this event together. And then one housekeeping item that I've been asked to address. There will be opportunities for photos with the justices afterwards, and apparently everyone from Big Rapids High School and from Ferris is already all set. But if you're not from one of those two organizations, you will notice on the last page of the brochure there is a photo release form, and we would ask that you fill that out and give it to one of the volunteers. I assume you're okay with photos. So one of the things that I enjoy about my job is that I usually get to go with the justices after oral arguments, and I sit with them and I hear them discuss the case. And that's what's happening now. They are back in a room behind us, and they are meeting to go over the briefs that were filed in the case. They are discussing the questions and answers from oral argument, and they're kind of just picking each other's brains about what they think should happen in the case. At this point, they have a whole range of options open to them. They could simply deny leave to appeal, which would let the lower court decision stand, or they could decide that they are going to reverse the Court of Appeals, or they could decide that they are going to affirm the Court of Appeals, which means to write an order or opinion saying we agree with the Court of Appeals. If they decide to do something very simple, like an order, it could come out within a matter of weeks. An order is just a couple of sentences from the court with a very briefly saying we're doing X or Y. On the other hand, if they decide to do an opinion, which is kind of opinion is much longer, it's a description of the facts and the law and the legal points, and if they decided to do an opinion, that it might be months from now before we see anything. The one thing that I do know is that all of the justices have given a lot of time and a lot of attention to looking at the law and the facts in this case, and they are considering the parties' arguments, and they are back there having a civil discussion that includes listening to each other carefully and thoughtfully considering everyone's point of view. And that is what I truly appreciate about this court and this branch of government. So now we're going to have about 25 minutes for questions before we head to the reception, or actually before we do photos up here. I have some questions I can ask if the room goes silent, but frankly I'm hoping that does not happen because my My hope is that all of you have a lot of questions based on the argument that you just witnessed. So don't be shy. If you do have a question, we really want you to come up and ask it. I'm hoping that the microphones that... Would you try?
Can you hear me?
Yeah. Is it going to be volunteers? Oh, I see. Oh, there's microphones up here. Okay. Yes. So if you, thank you. So please feel free to come down to the microphones if you have a question. And to kick things off, I'm going to ask the attorneys to introduce themselves. When we're in court, we usually start with the appellant. So I will begin with defense counsel, two defense counsel today. So if you could just say a little bit about, introduce yourself and say a little bit about what you do.
Sure. My name is Zachary Houghton. I work at the Kane County Office of the Public Defender. I serve as the training director there. I supervise two research and writing attorneys, and we are primarily focused on motion and appellate work.
Okay. And the appellee, prosecutor?
Excuse me, Kimberly Mans. I am at the prosecutor's office in a dedicated division of 4 prosecutors just dealing with appeals and motion work. So I've done that for almost 20 years now.
Okay, so I'd love to get some questions from the audience. Somebody must have a question. Oh, I will start over here to my right.
All right, can you hear me? Oh, all right, can you hear me? No. No.
Test.
You just got to get closer. Okay. I apologize. I would like to just take one moment. I did not specifically introduce my colleagues that are here with me today. And so, not only if you're not arguing to the Supreme Court, but you actually have to talk in front of a number of people, you get really nervous. So I actually did forget, and so I apologize. Judge Clapp is here today. She is a 49th Circuit Court judge. And Judge Thompson is our probate family court judge. And again, I apologize. Thank you for letting me introduce them. Again, I too get very nervous. I'm a judge, but I get very nervous. Thank you.
So we'll alternate, so we'll go to my left next.
Okay, so my main question was for the appealee. So if the car was owned by a parent or any individual, because I know some people do continuously smoke weed, and it could be a shared vehicle, so that could be where the scent come from. If it was a constant smoker, it could seep into the seats or the smell of the car, which could be the reason for it. So does that still go with your ruling of
And I know it'll stick to clothes and things like that. That's one of the reasons why I talked about what an officer can tell from experience. But if you have an odor of marijuana and nobody in the vehicle can legally possess it, even if Uncle Joe was in there yesterday just toking up, you would hope they wouldn't be, because one of the things that MRTMA does not allow, and it continues to be criminal, is using, obviously, smoking while you're driving, being under the influence, smoking in the passenger compartment of a vehicle. All of those things you cannot do. So the answer to your question is, under the argument made today, yeah, that would potentially still be probable cause if the only people in the vehicle are under 21. Again, we make the best arguments that we can make, given whatever cases come to us at the time. I have no idea what will happen with this. They can't hear us, right?
No, they can't.
Okay, I just want to make,
The video, though.
I just want to make sure. I mean, I could foresee the search of the driver, them saying, oh, yeah, nope, we're going to kick it because of that. I don't know if they will or not. But yes, the direct answer to your question would be, yeah, that could still be probable cause if it's only teenagers driving and there's the odor of marijuana. Now, obviously, if they search it and there's nothing there, then no problem. If they search it and there's marijuana, then it's possible civil infraction. So still not a misdemeanor or felony unless you have so much of it that it reaches that level. Then it can still be a criminal offense. Okay, thank you.
Am I right?
I probably should say we're not allowed to give legal advice. so that's just my opinion.
Hello. I also have a question for the appellee.
I am not evil. I should say that up front, just because, okay, yes.
So, correct me if I'm wrong, but in prior cases, there has not been an established precedent that contraband refers to anything other than criminal items. Where was kind of like the basis of like the understanding that you came to that contraband refers to like illegal stuff as well, or anything unlawful?
The Fourth Amendment language itself. The Fourth Amendment doesn't say if there's probable cause to believe a criminal amount of contraband or evidence of a crime. It simply says contraband. There have been some states that have, and I thought you would bring this up actually. There have been some states that have made that distinction in case law and said it has to be probable cause to believe a criminal amount of contraband is in the vehicle, which honestly I'm not sure exactly how you would ever reach that level if that's the case. But that is, to me, adding language to the Fourth Amendment itself when it's not there.
Okay, gotcha. Thank you.
To my left.
So maybe again more for the appellee, but really any law thing. The question is, and part of the probability was denial, him denying that there was there. Why does that factor into adding to probable cause when there's the probability that maybe he was telling the truth?
I think that factors in, for the Court of Appeals, that factored in more with the passenger admitting that there was marijuana in the car. Because both of them had said, no, we don't. The Court of Appeals took all four of those factors. They took the odor, the ages, the denial, and then the passenger saying, yeah, there's a little bit. In my opinion, once you have the odor and the ages, and no one can legally possess any, that's sufficient. Does that answer your question? Or,
I think so.
to me, the denial was, the denial without the passenger admitting, to me, wasn't as important.
Yeah, okay. Thank you.
I have a question for the appealee. Okay, so when it specifically comes to marijuana nowadays, there are many different strands with like several different like not flavors, apologize, aromas when you burn it.
Sure.
And especially when it comes to synthesized and processed THC, when that happens, any type of scent that the processor wants to take off of it can usually be like removed, or then more can be added. So what I was asking is, when it comes to that, like the scent of marijuana in the car, at what point is it reasonable? Because there are many, many, many different smells of marijuana.
Okay. It'll go back to what experience the officer has with it. It's interesting if there's, as you indicated, ways to minimize the odor. I mean, that's some dispensary. Somebody needs to patent that and makes a whole lot of money.
Also, if just the smell, like you said previously, if just the smell and the fact that the driver is minor
Yep.
is at that point, the officer has a reasonable suspense to search the person and or the car.
Well, just the car, not
Just-
the person.
Oh, sorry, just the car. At what point does it stop an officer from just saying that they smell marijuana and then searching the vehicle to find
I
illicit
mean,
goods?
that is a rub that we have with any offense. I mean, we should and do expect our officers to be truthful, but as you said, if someone's going to lie about that, that's why we have things like if an officer is caught lying or doing something like that, there are certain lists that we have to keep, and if an officer has done that in the past, then any case that that officer is going to be a necessary witness on, we notify the defense attorney so that they can bring that out, that this officer has been, proven not credible. But yeah, there's always the possibility that you have somebody like that. It is really just making sure that the system that's in place is holding them to being truthful and really making it so that they're not going to be in that position long if they're not, if
Okay.
that makes sense.
Thank you for your time.
Yep.
Okay, to my left.
My question's for anyone who wants to answer. So when I first heard about the case, I agreed that the officer was in the right to frisk and search his car. But after and for a civil infraction, but after I heard it be compared to a speeding ticket, which is also a civil infraction, I thought about the fact that I've never seen anybody or been in the car with somebody who has been pulled over for speeding and taken out of their car, frisked, and had their car searched. So my kind of question is, are all civil infractions made the same? And if not, should there be certain laws and rules that differentiate other crimes and civil infractions for cases like this?
No, there's not a distinction when it comes to civil infractions. When it comes to criminal offenses, there's a distinction between misdemeanors and felonies. As to your point about speeding tickets, if we extend the automobile exception from a situation where you have probable cause to believe the car contains evidence of a crime and extend it to probable cause that the vehicle contains evidence of a civil infraction, it is going to implicate situations beyond the marijuana context. And so, counsel over here disagrees, but for example, speeding, I raised this in my brief. If you have speeding, there's a black box in your car, there's probable cause to believe that might have evidence of your speeding. If you have a recorder on your dash, that might, and you're accused of rolling through a stop sign, maybe that video is probable cause of that offense of rolling through the stop sign. If the officer believes that you were texting while driving, again, you could have maybe the phone taken. And so I think I know counsel disagrees, but I think there are implications beyond the marijuana context in this case.
That is why I was trying to argue, I hope they got my argument, that it should be limited to contraband. It should, probable cause to believe a civil infraction, but only as to contraband in the vehicle. That way you're not getting into the situation where, as opposing counsel suggested, anything and everything. The Fourth Amendment specifically says contraband. So if we limit it to that, whether it's marijuana and no one legal is in the vehicle to do that, or you have probable cause for other reasons, for another investigation, that there's drugs of some other kind, then yeah, that would be that's where I'm trying to draw the line, if that makes sense.
So you agree that even though they're both a civil infraction, that it should be held at a higher standard for like searching and
What I'm suggesting is, again, limited, and today we're just talking about the automobile exception, that it would be limited to probable cause that there's contraband in there. So it's not changing a standard. Standards for any other civil infraction would stay exactly the same. Standard for, well, and the standard would stay the same as well. The standard for civil infraction would stay the same across the board. The ability to search would be whether there's probable cause, you have a reasonable ability or fair probability that evidence, in this case, not evidence, contraband is going to be found in that vehicle.
okay. Thank you for your time.
Yes, sir. Ma'am.
Hi. My question is for anybody who is willing to answer. Was the gun loaded, and would that affect the case at all, if it was?
This is an interlocutory appeal, so I'm not going to answer that question.
What that means is the case is not going to trial yet. So there's certain evidence that may be in dispute, so we can't really get into that at this point.
Okay, thank you.
Thank you. On my left?
So the right to have a gun, like have it licensed and in your name, this is for any of you. To own that, wouldn't you have to be 21 years old, correct? Just not if that's correct, please, because I don't want to look weird. So using the Terry frisk to search him for the officer's own safety and to see if he had a weapon upon him, would that become unnecessary for him to not have a weapon, or what, because he cannot own a gun yet?
So a Terry frisk is permissible if you have a lawful stop and the officer develops reasonable suspicion that the individual is also armed and dangerous. So whether the individual ultimately has a gun or not is irrelevant. If the officer develops reasonable suspicion that the individual is armed and dangerous, the officer can conduct a pat-down search. Does that answer your question?
Yes, thank you.
Hi, I just have a clarification question. So, was there actual evidence of marijuana found in the vehicle? Like, did the officer actually find marijuana?
Again, it's an interlocutory appeal, so I don't want to
Okay.
answer that.
So then also, like, because I know there's a lot of people around here that hunt. So, like, if the handgun had been in the case in the back seat and the officer went up and saw the handgun, like, in the back seat or something, would that have not been as big of a deal? Because, like, you can be 16 and have a rifle and go hunting, right? Or no?
Again, no legal advice here. There are certain requirements for carrying a pistol.
Okay, so it's different between, like, a rifle and a pistol? Yes?
If you're transporting a firearm and you're at least of age to own one, there are requirements to have you have it in the trunk and have it separate from ammunition.
Okay.
Basically, and if you don't have a trunk, you don't want, the goal is not to have a firearm can't be within reach of the driver when you're doing that. You have to have a CPL, a carry concealed permit. Yeah,
Okay.
you have to have a permit if you're going to carry it in the vehicle with you, on your person, in a glove box, anything like that. You have to have that CPL. If you don't, then that's when you will potentially be charged with carrying a concealed weapon. If you're transporting a firearm, like you said, for hunting purposes, things like that, it needs to be unloaded, it needs to be in the trunk of the vehicle if possible. And these are things that any hunter should look up for themselves as well, because I can spout what I would suggest you do, but I can't give legal advice to you. So any of that stuff is going to be online as well as to how you transport firearms safely.
Okay, thank you.
Back to my left.
My question is more towards both sides, but say after the friend confessed to having the sustenance in the car, or say, would you say that if they confess, the officer has like enough, I can't find the word, like, would you say that the officer has like enough permission, as in what they said, to search the vehicle for that sustenance if they like, if they like said that it was in the vehicle?
So this is the crux of our disagreement. I would answer no, because I maintain that an officer has to have probable cause to believe the car contains evidence of a crime, and assuming an admission of that sort, I don't believe that gives you probable cause to believe that the vehicle contains over 2.5 ounces of marijuana. I think Sister Council would hold that the automobile exception is broader, or in my terminology, should be extended to civil infractions, and that would be enough.
And I guess I disagree that it's extended to civil infractions. It would only be civil infractions dealing with contraband. I don't know if that makes sense. But if you have somebody in the vehicle who says, yeah, I do have some, it's in there. Again, my argument is that's probable cause to believe there's contraband in there if everybody's underage. That's probable cause to search the vehicle. But it might limit who's going to be getting a civil infraction if you have somebody that's saying, yeah, that's mine.
So what if they only said that there was like a little amount, but not the exact amount, like enough to be a civil infraction or over the limit of too much?
Well, assuming that the individual doesn't have a medical marijuana card, any amount of marijuana possessed by someone under 21 up to 2.5 ounces is a civil infraction.
Thank you.
Hello. So 2 quick questions. The first is, as the attorneys, did you get an opportunity to say, yes, you wanted to participate in this, or is it the Supreme Court saying, we've picked Mr. Wilkins' case and now you have to be here?
We were given the opportunity to say yes or no. I thought that there were probably feelers out for multiple cases and that they would then choose afterwards. I found out later that they were really hoping we said yes because this was the one that they wanted to put on.
Well, thank you for saying yes. It's terrifying to make arguments in front of this many people, but thank you. The second question I have, though, is we've heard a little bit about what the Supreme Court might do, the options that the Supreme Court can do in this case. Can you educate the students a little bit practically what that means? So if the Supreme Court agrees with the appellant, what does that mean potentially for Mr. Wilkins, practically speaking, or in the alternative, if the Supreme Court agrees with the appellee?
I guess I would want to speak in hypotheticals and not to the facts specific to this case. Does that make sense? Potentially, if they agree with opposing counsel and say, smell alone, even with underage, that's not enough for a search. I'm not sure how they would.
Let me ask it this way, maybe to clarify a little bit better. If, hypothetically, the Supreme Court says the evidence is suppressed, what does that mean, practically speaking, for Mr. Wilkins' case?
Mr. Wilkins' case will be dismissed because we will not be able to use the firearm that was found during that search if the search is suppressed.
And if the Supreme Court of Michigan says, no, it is not going to be suppressed, what does that mean for Mr. Wilkins?
The case will move forward. There will be plea negotiations, possibly a trial. He can be held guilty or not guilty. It will proceed as normal.
Perfect. Thank you.
We only have time for a couple more questions. I apologize. I will say that there is a reception afterwards, and the attorneys will be there, so you can feel free to ask them questions at the reception as well. So we'll go ahead on my left.
This question is kind of for anyone, but I believe it was said that the officer didn't specify if the weed was fresh or not or how it smelled. So if he specified the smell of it, would that like impact this in any way?
No, I don't believe so. The reason is marijuana gives off a powerful smell that lingers for hours, and so it's not, I would argue that's not particularly probative of who's using, how recently, or where.
I would argue that if an officer can say, oh, I'm smelling burnt marijuana, that's going to be something to consider whether he thinks someone is driving while under the influence of marijuana, or whether someone else has smoked marijuana inside the vehicle while it's moving, which is also not allowed. So to me, the distinction between burnt marijuana and not is something we would at least argue.
Okay, I'll do one more question. We'll go back to the right here.
Thank you.
All right, so so do we know how long the people were like waiting for, like, after the search was done before they admitted to actually having the marijuana in the car?
I think the prelim transcript suggests that after the officer had collected the driver's license and so on and so forth, he went back to the car and it was 5 to 10 minutes.
Okay, thank you, everyone. I appreciate you coming today, and many thanks to our attorneys, Kimberly Manns and Zachary Houghton. I would also say, like, at that reception that's coming up, with the questions that you didn't get a chance to ask, you can ask the attorneys or go directly to the justices. The justices will be there, and they like talking to the students, and they want to get your impressions on what you saw today and what happened. And so feel free to ask questions of the justices as well at the reception that will follow.